Thank you, Madam Chair. I don't know if you can hear me.
Yes, we can hear
Okay,
you.
perfect. So the microphone and device works. Thank you, Madam Chair. And first of all, I would like to thank the organizers of this course, especially Igor Vio, and for having organized this course, but also for having successfully implemented it in this hybrid version in order to enable us not to lose this occasion to see each other in this virtual way, at least. And today I would like to focus on what is blockchain and what are smart contracts, but also what are the challenges and the actual implementation in transportation and international sales contracts. I will not deepen the issues of electronic bill of lading, which have been already successfully addressed by Patrick Vlasic. I think that, first of all, it could be useful to set the scene and understand what blockchain technology is and what the smart contracts are in order to understand what are the legal issues. First of all, what is in a name? Here we're not discussing about Rose, as in Romeo and Juliet, but we are discussing about blockchain. And actually, as the name suggests, it is a chain of blocks. Why blockchain is different from other digital systems and solutions? Why there is much talk about it? Because it grants integrity of a record, and it renders really difficult to forge the record and also double spending. It consists of a block, so you can include in each block a transaction with an economic value. Blockchain is most renowned for bitcoins or other cryptocurrencies, but actually the bitcoins are its first usage, but nowadays it is really important in the business world for other possible and also actual applications. So you can incorporate in this electronic block a transaction with a certain value, and this block is strictly enchained to the previous others, because in its content it has also the hash, that is the name, the identity of the previous blocks. And all these information are converted into another hash, that is the block's hash, that is included in the block header. So the participants in the platform can see the block header and can assess whether its content is correct, whether it was forged, whether it is a fraud or not. Blockchain is based on the symmetric system of keys, a public key and a private key. That means that the author or the record can create the record by using his own private key, and the other people participating in the platform can assess that he is the real author of this record. This is nothing different from other systems. What is different is this system of strictly connecting the different transactions one to the next other. How is it possible? Let's take a prospective transaction. I draft it in the upper left corner of the slide. So let's think that there is a person that needs to transfer money to another person. How is it possible to incorporate this transaction into blockchain platform? he can transform this transaction into electronic record in a blockchain platform. Then this transaction will be assessed, validated, not by a central ledger, a central authority, but by all participants in the platform. So this is not a centralized platform with a central ledger like the traditional ones we are used to know. It is a decentralized peer-to-peer platform. Each user is a node in this platform. It is called miner, and each user is associated a ledger. And the miner, I think every 10 minutes or so, more or less, assess and validate the transaction. Once the transaction is assessed and validated by at least the majority of the miners, it becomes a part of the chain of blocks. It can't be separated by them. So these grants, these records ensures the integrity of these records against the risk of forgery, because you must have all the participants in the platform, or at least the majority, to agree to change these records. So it is not completely impossible, but it is very, very, very difficult. What is the difference? The traditional systems are called closed centralized systems. So they need a central ledger that is managed by a central authority. And let's take, for example, the example of electronic bill of lading, which is, I think, the most important and also useful example. Here, the system of public-private crypto keys enable to assess that the author of a record, of electronic record, is really that person. But actually, it does not avoid double spending. Double spending is avoided by the central authority that assess each transaction and record it in the ledger. That means also that they need to be closed systems, and they are not able to realize the equivalence of electronic bill of lading to the traditional one, because we are not able to, for example, to have a bill of lading circulating among any potential users. Users must be part into this closed system. Once more, we know that traditionally the functions of a bill of lading has been based on the law. So the bill of lading is a document of title because the law at the international level, but also at the domestic level, recognize this effect. On the contrary, here we have a problem because this system can't grant the equivalence, the functional equivalence of electronic bill of lading to the traditional ones. The mechanism of transferring the bill of lading is granted on the basis on the agreement among the different users and a central authority, and through the institutions of novation and attornment that are really different from how our traditional bill of lading works. On the contrary, with regard to the centralized peer-to-peer systems, we have no more this central authority, and the document can, the electronic record can circulate by transferring the control over the record. This enables the system to avoid the risk of double spending The transaction is almost simultaneously verified on every ledger. So this enables users to avoid or make very, very difficult the risk of forgery. Some problems or disadvantages of these systems is that we are still no uniform legal basis, no uniform regime at the international level, sometimes also at the domestic level. And we can have open platforms or closed platforms. Open platforms enable the electronic record to circulate among any potential users, but the identity are not known. So they are known as nicknames, which is not the case of closed platforms that are also called permissioned blockchains. Both the types of platforms are important in the transport sector because, for example, with regard to bill of lading, it could be useful to have a permissionless blockchain platform, or at least, as Patrick Vlacic mentioned, to grant interoperability among the different platforms. With regard to other usages, blockchain transport sector, such as passengers' rights, it could be much more useful and effective to have closed platforms, permission blockchain platforms created by the carrier. But I mentioned before that there is really much talk about blockchain. Everybody is mentioning blockchain for every single moment. Are we sure that the blockchain is always useful? So every time we have a problem issue, we must resort to blockchain? Not at all, because blockchain is not useful when we simply need a database where to record and exchange information. Blockchain is useful when we have a competitive environment where there is much distrust and we need the users to trust one each other and to ensure integrity of a record, avoiding forgeries and double spending. In the other cases, let's go with traditional digital devices. One of the most important applications of blockchain technology in our world are smart contracts. What are smart contracts? We can call them as automatic contracts, but actually contract here is a false friend. Smart contract was described by this famous Nick Szabo, which nobody ever saw, I think, in 1994. So really far before blockchain creation, as a computerized transaction protocol that executes the term of a contract. The most renowned examples are vending machines. A smart contract is based on code, on instruction, on this type: if X, then Y, if W, then Z, and so on. So, like in the example vending machine, if I want to purchase that chocolate bar, I read the number, the code of the chocolate bar. I write in the machine that number. I put in the right amount of money, and then the machine, if it works properly, of course, if there are not problems, will give me that chocolate bar. So, but in this case, what are smart contracts? This is a very discussed issue. Some people believe that they are not contracts in the traditional sense. They are legal relationships, but they have legal binding effect, but without a contract, without a traditional contract as a basis, but ex lege. On the contrary, according to other scholars, they are simply different ways of performing an already existing contract, or on the other hand, they can be considered a contract concluded by behavior, per facta concludentia, like in the case of a vending machine. according to my humble opinion, that is opinion also of the other most important scholars, much more than me, we must actually assess the actual case, because in certain cases, smart contracts are only ways of enabling the performance, the automatic performance of a traditional contract. In other cases, actually, like, for example, in the example of the letter of credit, I will mention you in a few minutes, there are ways of concluding and also performing, so executing and performing a contract, who has its regime who is governed by the traditional regime depending on the specific contract. So there is, according to me, in many cases, nothing new as with regard to the legal regime. What about our sector? I hope that this introduction was clear, because there are really technicalities that are difficult, and I tried to explain them in the simplest way possible, and I hope that I was clear. What about transport sector? Let's take the example of food traceability, because it is a very important issue. Actually, we have this case of Carrefour that, for marketing purposes, told the customers that they were enabled to track back their food from the farmer, for example, that produced chicken to be eaten, up to the different steps. But actually, in this case, really, it is an example for marketing purposes, because this is not an effective way to use blockchain. We use blockchain when we need to deal entirely with information that were born and live in electronic version. In this case, not all the information were born in the electronic version, because chicken are living beings. So you must trust that farmer and the information it upload in the system. This is a different case from, for example, electronic bill of lading. Another important example, however, is a spinach, Escherichia coli disease in a spinach product in the United States in 2006. In this case, blockchain technology applied to the distribution of these products would have probably enabled the authorities to track back the origin of a spinach disease, and also where these products were sold and consumed, in order to stop before they could do it, the disease. But actually, let's consider the effective cases where blockchain and smart contracts are really useful in our world. In the with regard to logistics, transportation, international sale contracts will deal with a huge number of documents and information, and many obligations refer to exchange of these documents, to a preparation exchange of these documents. We can transfer these obligations, transforming them into smart contract instructions, and transfer these documents in the platform as electronic records, in order to enable their exchange in a faster way, granting their integrity from the manufacturer, for example, to the final consignee. Another example that is an actual, but will concern actual project, is letter of credit, because all of us know that banks deal with documents. So with regard to the documentary credit payment method, banks deal with information the information included in the letter of credit, that includes the requirements the seller must meet in order to get paid, the information included in the bill of lading and in the other documents that the seller must submit to the bank and must conform with the letter of credit requirement. So we can transform this process into smart contracts and electronic information. I can't use smart contracts, for example, blockchain, with regard to non-conformity of the goods that are delivered, because we are dealing with physical goods that need to be physically inspected, but I can incorporate into the system the information that would have been included into paper contract. So we can create documentary credit process from very beginning, from the application for letter of credit, because it refers to electronic records, to an application electronic form to the issuing bank, up to the final payment of the carrier. If we deal with, for example, bill of lading and the other documents, I presented them with these cubes that can be delivered to the platform, to the confirming bank, enabling automatically payment by the system. The system will check if all these documents conform with the instruction he has already saved in his database, then it will authorize payment without the need, for example, of a clerk checking the document. What could be another possible usage of blockchain? We know that in the European Union, there are standard rights for passengers in a different transport mode. For example, the right to standard compensations, provided that the flight or a trip is cancelled or delayed for up to a certain amount of time. So we can perform. This is a case of, for example, performance of a contract. We can enable performance of these obligations by the carrier to a blockchain system. Whereas in the case, for example, previous example of documentary credit, I think it is a case of conclusion, not only performance, or conclusion of a contract through a blockchain system. In this case, I think that it is at least a way of performing the obligation of the carrier with regard to assistance to passenger and especially compensation. So if in this case the flight is delayed up to a certain time and our train is delayed, the system through these oracles, these tools are called oracles. Oracles are bridges that connect the real life with the virtual platform. So the oracle incorporated into, for example, the airport system will inform platform, okay, the flight has had a delay of at least 3 hours. So the platform will enable payment, automatically enable payment to the passenger through the platform. But this is quite very nice, but what could be the problem? Because at this point, many stakeholders say, okay, there is no more need of law. The system, the code is the law itself. There is no more need of lawyers, because everything is performed automatically. So it would be a problem for us, for many of us, I think. But I think that this is not true, because what does happen? Because first of all, as I mentioned before, not all the obligations can be effectively performed through this system. What happens when the contract is void? The system does not recognize the problem of a contract void, for example, for lack of willingness of the party to be a party to the contract. What does happen if a passenger does want to exercise his rights under, for example, 1999 Montreal Convention, or again, with regard to termination, if in the meanwhile certain causes, grounds for terminating the contract have arisen, how can the system recognize them? How can we incorporate them in the system? At this moment, I think that systems can't be implemented with all these issues. And once more, many of us belong to civil law countries. What about the implementation, the enforcement of general interpretable principles such as good faith? Good faith can't be automatically performed. For example, the system could be much more conforming with the principle of reasonableness that in common law, it's a principle that limits the party's discretion. If we automatically perform a contract with no more discretion, but it is almost impossible, I think, to enforce good faith with regard to these principles. So there is still room for us. Another problem is how these systems are programmed, the code itself, because this is an example. The DAO case, the Decentralized Autonomous Organization, was the first digital example of digital decentralized investment fund that enabled investors to invest a certain amount of money converted into Ethereum, that is another cryptocurrency, the second most important cryptocurrency after Bitcoin, in startups. So they converted the Ethereum coins into DAO coins, and then they were able to finance a startup that the given startup will convert again DAO coins with Ethereum and then spend the actual value in the real world. But there was a problem about the code was created, because there was a problem of coordination between the different transactions. That means the time when the investor invests its money in a startup and the updating of the ledger. And this enables hackers to take advantage of this bug and to raise many money, to steal many money for him. But actually, according to the users, to certain users, this is not a case of crime, because they say code is law. If a code of DAO enabled this operation, that the hack is legit. So there is still room for lawyers. But what about law sources? At the international law, we have the United Nations Convention on the Use of Electronic Communication International Contracts of 2005 that have been ratified by 14 states, if I'm right. And this convention enables the equivalence of electronic communications to traditional communication. So this could be and is the legal basis for many of the contracts performed through these systems. But in our world, there is a but, because it does not apply to bills of lading. There is a reason, because at that time where this convention was negotiated, the Rotterdam rules were still were already being negotiated too. So they supposed to be ratified and enter into force as an actual convention, effective convention, but this is not the case. Another problem is that we have many different domestic law. some law does not really are viable because they, for example, in Italy, we have a problem because last year or in 2018, legal provisions in order to make blockchain technology smart contracts effective and recognized in our system, in our country, were enacted, but actually they do not grant technological neutrality. And that is a huge problem. So, for example, the Italian provisions that, as far as I know, have not been implemented yet, are not feasible in the international context. We have different model laws, but actually they are model laws, so they don't grant by themselves international uniformity. And they do not have rules specifically addressing the transfer and negotiability of electronic bill of lading. Because actually, as I mentioned you before, the electronic bill of lading is a huge problem because its functions derives directly from a law, as developed by Lex Mercatoria and then by domestic laws and international conventions. So you must have an international uniform regime granting these effects for electronic bill of lading. Otherwise, we will go still with novation and attornment, that is different. So I would like to skip this presentation and go strictly to the actual regime of bill of lading. With regard to the most renowned Hague-Visby rules on bills of lading, they apply to contracts of carriage covered by a bill of lading or other similar document of title. An electronic bill of lading is a document of title when there is a legal basis that says it. So as far as we have no law provision, no hard law that says that the electronic bill of lading is a document of title, I think that is quite difficult to apply Hague-Visby rules per se. With regard to Hamburg rules, on the contrary, we can provide a wider interpretation for them because they refer to also not only paper documents, but also telegram and telex, that were the devices that were available at that time. And also, they provide also that the bill of lading can be signed also by other mechanical electronic means if it is not inconsistent with the law of a country where bill of lading is issued. So the Hamburg rules, according to my humble opinion, are less problematic than the Hague-Visby rules, but still there is a problem reference to a domestic law as a legal basis for the equivalence between the electronic signature and the paper signature. As usual in our history, the business world did not stop, so it provided for different contract clauses and models as a basis for the equivalence of electronic bill of lading to the paper bill of lading in a certain way. Many of them were already mentioned by Patrick Lacic. With regard to documentary credit, let me mention only the last version of electronic UCP 600, which are, as far as they are incorporated into letter of credit, the legal basis for I think, for this kind of tools. So again, I think that as in the medieval ages and the 19th century, waiting for the legislator, the lawmakers to provide, to fill the gap at the domestic international level. The business world is going on with the renowned Lex Mercatoria. But with regard to bill of lading, for example, it is necessary to solve this problem as a solution, for example, by including a paramount clause that will enable to apply Hague-Visby rules by contract to the bill of lading. And it is necessary to coordinate the different contracts involved in the process. Thank you very much.
Thank you very much, Professor Orrù, for your presentation, and thanks to all our speakers in this session. So now it's time for questions and discussions. So if you have any questions for our speakers, they are on your disposal. So.
Maria, hi, this is Diana.
Hello, Diana. Hello, nice to see you.
Yeah, I would just have one comment, or I think it would be important to mention. It's with reference to Professor Vakhari on electronic ship certificates topic. I think it's important to say that the list of the countries from one of the slides, we should probably add Croatia as well. As you all know that with the latest amendments to the Maritime Code, we have made a kind of a frame, legal frame from electronic businesses with regard to registration and the issuance of the ship certificates. So those provisions have entered into force the beginning of 2019, and the Ministry of Maritime Affairs, as far as I know, has already made a kind of platform for such electronic certificates. So I think I just think it should be important to comment and to say that. Okay, thank you.
Thank you, Diana. Any comments, please?
Yeah, thank you for that comment. Actually, very much appreciated. And it's very interesting to hear about the development in Croatian law. I didn't actually do, I must say, a thorough search, but the information I provided you on the slide is from the IMO database, and it seems, unless I'm mistaken, that there was no official communication from Croatia on the subject. So I just took the official notifications. Yeah, I would imagine that the new maritime legal, the new Croatian Maritime Code of Croatia, maybe something that happened with the legislator, but the Maritime Administration didn't yet notify the IMO.
Probably.
So it happened something, yeah. But I think it's something that you should be proud of, and you should perhaps, as a, maybe we could exhort the Croatian Maritime Administration perhaps to notify IMO.
It was a kind of aim to promote Croatian flag as well. Yeah, thank you.
Thank you very much. Maybe more questions?
Yes, definitely Alex's presentation.
We can't hear you.
Microphone?
Yes, please.
Yes.
here, please.
Can you hear me now?
Yes.
Arif, if you remember, as we planned the first version of the course, we planned even 3 lectures for you. One was the continuation from your last year's speech about fighting maritime corruption and shipping in IMO. And the other entire lecture was supposed to be dedicated to the single maritime window. Of course, we are hoping that next year you will come and be able to deliver those. But maybe you can tell us now just a couple of more features about the single maritime window, because it really seems like an interesting thing.
Sure, thank you, Igor. I actually joined Elena, who was, and sorry if I arrived a bit late into the session. I had some technical issues. I'm actually transmitting to you not from Sweden, but from Beirut, which sustained a major maritime port disaster just a few weeks ago. So I was able to actually check a bit on the scene. In terms of the question of the maritime single window, I think we're a bit behind schedule in terms of the IMO expectations and milestones, because already last year, 2019, all IMO countries, all IMO member states were bound to have systems, that system in place, the famous maritime single window. There have been many pilot projects, and clearly the IMO is kind of the victim of its own success, because the approach it has taken was to actually include in the Falcon Convention the requirement that by April of 2019, the maritime single window should be a reality in all port and maritime administrations. But these pilot projects that have been developed are very often history a few months or a few years later, because they are overtaken by new technology. And it remains that in many countries also, the significance of this requirement has not really trickled down to the powers that be that can actually shape the setting up of the systems for this reality, for this new reality. Obviously, with the COVID-19 and the pandemic, everything has been given an extra push for everything related to digital documentation, and as well as remote monitoring, remote inspections, remote verifications, including port state control. And I would imagine that MSW will continue to feed the demands of the maritime community, not just because of the benefits to commerce, but also because it's a way to avoid human contact as a palliative, or as a precaution against the outbreak or the transmission of the disease. Just like the requirements of electronic certificates, the maritime single window, interestingly, even though there's just one short paragraph in the FAL Convention, which is actually core, it is binding law on member states, but how to actually carry out the maritime single window is subject really to soft law instruments. So there are guidelines on the topic. There's no defined manner for them, apart from safeguards that are recommended for states to take into consideration. And I think it's understandable because the technology is fast evolving and one solution cannot fit all the requirements. Remember, we're talking about e-government ultimately, a bit like perhaps what we heard from Elena earlier about the Italian experience, and now the Croatian maritime code. So these are perhaps elements of what is going on about maritime single windows.
Thank you very much, Aref. Maria, will you let me take over the moderator role just for the... Are there any more suggestions, comments, or questions? In that case, I would like to thank to our speakers, to Elena, to Patrick, and to Aref for their excellent presentations. It's also my duty to convey you regards from Mrs. Maja Markovčić-Kostelac. Many of you know her. For years, she has been working at the Croatian Ministry for Maritime Affairs. Now she is Director of European Maritime Safety Agency, EMSA, and we were planning her personal participation. Then she went to Lisbon and she couldn't travel. And finally, she couldn't even connect online because of her numerous duties. But we were looking forward and are looking forward to her participation. Perhaps next year, she would like to give a broad lecture about EMSA and current activities and strategy for the future, but also specifically activities of EMSA with regards to autonomous ships, which would be also very interesting for all of us. So let's hope that Maja will contribute next year. And now we will have a lunch break